Hope everybody had a great weekend. Staying cool out there, hopefully. So today, if you missed it, Carr sent out a little fact sheet about leasing, and because there's been a lot of questions about leasing post NAR settlement. How do we handle the commissions? Do we have to have a buyer rep agreement? All these questions had come up. They just hadn't addressed yet, really. So. I'm going to go over that today, and then we're also going to talk about some leasing pitfalls, some best practices. So when we're talking about leasing, we're talking about tenant placement services, which you can do here at Rise Realty. Um, so that would be, either you representing a tenant trying to find them a prospective place to lease, or you doing tenant placement services for maybe one of your clients or something like that, where you are charging them a fee to market their property and find, a good tenant and do the lease agreement and all of that. It is not property management. That is something we don't do here. That requires trust accounts and things like that, and some really strict trust accounting. Um, so at this time, we do not have property management services here, but yes, you can do tenant placement services, also known as leasing. So we're going to go over that. So I say, let's go ahead and just jump into it. So first we'll cover the NAR stuff. So broker compensation for arranging leases or rentals post NAR settlement. And if you have questions along the way, go ahead and throw them in the chat. Um, the chat is open. So NAR settlement does not apply to lease or rental transactions. So this was something that I think that they didn't really convey very well in the beginning. Was that the NAR settlement pertains to single family home sales, 1 to 4 units. So when we're talking about leasing, or if we're talking about commercial transactions or a 5 unit plus building, the NAR settlement does not apply. It applies to the 1 to 4 unit sales. So just keep that in mind if you're wondering if you have to get a buyer rep agreement in place or not. So leasing falls under, does not apply. The recent NAR settlement prohibits listing agents from offering buyer agent compensation through the MLS, applies to sales of residential properties 1 to 4, not leases or rental of residential property. Now, I guess what makes that a little confusing is the MLS removed the offer of compensation just straight across the board in all the MLSs, which include leasing. So if you had, a rental that you needed to get leased and you were going to offer some sort of fee to, an agent working with prospective tenants, there is no way to offer this compensation, just like there isn't with the sales. So when MLS has removed the unilateral offer of compensation, they did so for all properties and all transaction types. Even though the NAR settlement did not prohibit a lease listing agent from using the MLS to offer cooperation to tenant agents, there's no longer a mechanism to do so since the compensation field's been removed. So how do you get your commission? So tenant agents can use form TRBC, one new form that they added. This is the tenant representation and broker compensation agreement to document the tenant's agreement to pay the agent for services. Although it's not common here in California up until now, reports exist that other locations in the US use this model. Like the BRBC for buyer rep, the TRBC contractually commits the tenant to pay if a lease or rental is entered into during the representation. The form also provides that the tenant will have the compensation obligation reduced if the agent receives compensation from the housing provider or others. So it works like the BRBC, not exactly, but it works like the BRBC. And so you can use that. I know most of the time, a prospective tenant's probably not going to want to sign that because this has not been customary in California, but it is something that you can do, and it may become more popular or more used since kind of the shakeup with NAR settlement. So tenant representatives can request a housing provider to sign the LCA. So one way a tenant's agent can request compensation from a housing provider, which would be the owner, is by using CAR Form LCA, which is the lease rental commission agreement. If the property is listed for lease or rental, the tenant's agent should give a completed Form LCA to the listing agent and request that the form be submitted to the seller before a lease rental is signed by the tenant and the housing provider. So, maybe before you used to give like an agency agreement or something like that. Now you can just have the LCA form signed stating what the commission agreement is going to be from the owner slash housing provider. So basically, just as you're doing now with offers by attaching the SPBB form, this is, I guess, a somewhat similar flow. You'll just provide this LCA. You'll say, hey, you're agreeing to pay me X, and hopefully you'll get it signed. And then that is your binding agreement for them to pay you for your tenant representation. Form LL, which is the lease listing for lease listing agents, does not provide nor address offers of compensation. Just like the RLA, it's not in there anymore. Broker-to-broker compensation language has been removed from the lease listing agreement. However, agents representing housing providers may individually negotiate with tenants' agents for compensation sharing, if authorized by an addendum to the lease listing. In that case, a compensation agreement between the two agents on behalf of their brokers have to be custom made by legal counsel. We do not have anything drafted like that. You can see right here, this is number 3 on the lease listing agreement. Compensation to broker, RPO agrees to pay the broker as compensation for services, and it says does not include compensation, if any, to a broker representing a tenant, irrespective of agency relationship. So it looks like the RLA, the new RLA. So, without getting too convoluted and having, legal agreements and stuff like that for compensation sharing, because this is really what NAR is trying to eliminate, is any type of compensation sharing, even though the NAR settlement doesn't apply to those lease listings. They just went across the board with it. So now we're kind of in this predicament here with the lease listings. My suggestion is, at this time, treat your lease listing like a residential listing by only negotiating your fee for service, your compensation, and instruct the tenant representatives to submit Form LCA to ask for an amount. Like you're having the conversations with your current sellers about, it's still good to be open about offering buyer agent compensation, and to have that figure discussed, hopefully, with your listing presentation. You're probably going to want to do the same with your housing provider that you're marketing the property for, and just say, look, if an outside agent brings in a prospective tenant and we decide to lease to them, it would be good to offer an amount of compensation for them to bring that prospective tenant. So maybe you have that built in already. Maybe the tenant representative is asking you ahead of time, hey, are you guys providing, any sort of compensation? I know in some areas, really, it's already, I know in North County, there is not much in the MLS for, for rentals that are listed in the MLS. And if there are, the fee is very, very low. It's really just not even worth it in most instances. And I know it's like that in a lot of areas. So, will this change for, the lease listing agents out there that, you know, rarely or don't offer compensation for bringing a tenant because they want to, you know, retain that entire fee previously. I guess nothing's really changed for them. They're just still going to charge their regular fee and not offer a compensation. But will we see things change a little bit? Who knows? You know, maybe it'll start to become decent to become a lease listing agent again if you're in one of those areas where it's just not really worth it. I know other areas, it is a little more worth it. Form RLMM recognizes that broker-to-broker compensation is permitted. Although the lease listing agreement is silent regarding the cooperating broker compensation, the broker's signature section in the residential lease or month-to-month rental agreement has language acknowledging that the two brokers can cooperate, but if they do, a separate written agreement needs to be created, which they are talking about, you know, right here, basically. So again, I think it's best just to, you know, have that lease commission form signed and have the owner just pay you directly, similar to probably what you experience now. Here's that section of the lease agreement itself. This is down where the agent sign. That says listing broker agrees to pay cooperating broker, leasing firm, and cooperating broker agrees to accept. And then if checked, the amount specified in a separate written agreement, which could be the LCA, that just makes it easy, and cooperating broker. So that's my take on that. So let's get into some pitfalls and best practices on if you are going to be, or, you know, if you're going to be a leasing agent, or, you know, even if you're doing this here and there, you have investor clients who, you know, maybe that's part of your service is like after the sale, you go ahead and get it rented for them. That is a licensed activity, whether you're charging them or not. It is a licensed and regulated activity. And so you can't take that lightly, and you don't want to get yourself into hot water because you're just doing, you know, a favor for your client. Um, there are a lot of strict rules with this, and you can really get caught up with some fair housing stuff real quick if you're not paying attention and keeping up with the laws that just are, you know, they're changing a lot and very rapidly. So leasing and property management are a licensed activity, both of them. Sales agents can only conduct licensed activity through their brokerage. So this is something that has to run through the brokerage, especially if you are putting this into MLS. We need a file on it. We have to document all of this stuff for the DRE and for MLS. So if it's in the MLS, we need to have a lease listing agreement, just like we need a listing agreement for a listing that's going to be sold. It is exactly the same. So those are the rules we have to live by. So we don't permit property management at this moment. So that would be month to month. You're taking a fee to manage this property on a monthly basis. Or you're accepting payments or anything like that. We do not do that. We don't even have the mechanism to be able to do that in a lawful manner because we don't run a trust account. So you have to have a trust account. Those are trust funds, and those are very serious violations if you are receiving any sort of payments directly from a prospective tenant or a tenant. And that actually includes like a background screening fee or credit check or anything like that. You cannot accept a payment and then go and run that report. You're going to want to do that through a third party system. I use Rent Spree personally. They've got a free-ish version that works totally fine. The tenant can pay Rent Spree for their credit check and background check. And so we're not touching those funds. So that is the way that it should be, because those are actually trust funds, and those will get you in trouble if you're collecting any sort of payment from the prospective tenant or tenants in place. Leasing, known as tenant placement services, is permitted. And I just went over kind of how the compensation works on that. So what are reasons why brokers might not permit leasing or property management activity? Lack of familiarity with leasing and property management is, in my opinion, probably the biggest reason why. Most of us are focused on sales. We don't keep up with all of the individual laws that are coming down and ordinances and things like that. Each city has different rental laws. So if you're not keeping up on every single city's, rental laws and rent caps and everything else they have going on, then you're kind of working outside of your area of expertise. Insurance does not cover this activity. E&O, it's on there as E&O, but we are not, performing property management. So the tenant placement services could be covered under E&O insurance. What kind of claims could come up? Usually fair housing. So that's the kind of stuff that you're going to see the most, is a tenant claiming that they were discriminated against in some way. Risk is different from sales. Again, fair housing, trust funds, those are the two biggest, areas where agents get into trouble when it comes to leasing and property management. And property management activity has to be reported to the DRE in the broker's renewal application. So attaching and filling out the Tenant Protection Act exemption notice. So back in 2019, California passed a statewide rent cap and just cause eviction law known as the Tenant Protection Act. Single family property, condos, and townhomes may be exempted, but are not automatically exempt if not owned by a corporation or REIT or EIT. The notice exempting these properties must be attached to the lease. You'll use the RCJC form, and you'll notice that that attaches to a few different things if you're doing any sort of tenant placement services or lease listings. The RCJC, which is a rent cap and just cause addendum. So exemptions from the rent cap rules. Housing that has been issued a certificate of occupancy within the previous 15 years. So essentially new housing. A duplex in which an owner occupies one of the units at the commencement of and throughout the tenancy. A single family or residential property, including condominiums, so long as the owner is not a corporation, not an LLC with at least one owner who is a corporation, and not a real estate investment trust, REIT, and the owner gives the tenant a legally required notice of this exemption, which would be basically in the RCJC form. Ownership by individuals, partnerships, individual co-owners, trusts, and LLCs with no corporate owners all qualify for an exemption. Giving notice of the rent cap exemptions, just use that RCJC form. And again, it already automatically attaches to pretty much everything you're going to be doing with leasing. For month-to-month tenants, for new tenancies, incorporate the RCJC into the rental agreement. It's going to attach. For existing, incorporate the RCJC by using a change of terms of tenancy, which is going to be form CTT. Fixed term leases, same method. Just make sure you have that RCJC form in there. Don't detach that from your package, your leasing package. Does the TPA, the Tenant Protection Act, preempt local rent control ordinances? So local government rent caps. If a city or county limits rent increases to an amount less than authorized by the TPA, then the local ordinance applies. If a government entity is not as restricted as the TPA, then the TPA applies. And you can start to see why, you know, not keeping up with this regularly can be very challenging, because if you are representing a tenant, or if you're representing a housing provider and you don't know exactly what that city's ordinances are for this, this is where you can start to get yourself in some hot water. So this is why, I think a lot of agents don't take leasing very seriously. And it actually is very serious, even though there's not, a lot of money involved in it usually, unless you're doing a lot of volume. Um, does the TPA limit the rent that an owner may charge a new tenant? It does not. The initial rental rate charged to a new tenant is not subject to the rent cap in the TPA. Subsequent increases to the new tenant will be subject to the TPA. Is it necessary for an owner to hire a lawyer before attempting to raise rent or evict a tenant? The application of the TPA and its many exemptions and requirements, as well as the interplay between the TPA and local ordinances, can be complicated, and failure to abide by the law can have severe consequences. For that reason, it's recommended that a property owner consult with a qualified real estate attorney familiar with not just with TPA, but also the local law. My suggestion is, do not answer this question if asked by a homeowner. Rise Realty, we're not property managers here. We don't offer those services. That is outside of our area of expertise, and we should not provide advice on property management questions. When an owner starts asking me that type of stuff, even I will defer them sometimes to an attorney or a licensed property manager, because I want to defer that liability onto somebody who is more authoritative in that, because again, we don't provide these services here. What are reasons an owner may evict a tenant for at fault just cause? Default and payment of rent, a breach of material term of the lease, the tenant commits a nuisance or uses the property for criminal or unlawful purposes, the tenant assigns or sublets the property in violation of the lease, the tenant refuses to allow the owner access, the tenant refuses to sign an extension renewal at expiration of the lease rental. What are reasons an owner may evict a tenant for a no-fault just cause? The owner is withdrawing the property from the rental market. The owner intends to demolish or substantially remodel the property. So cosmetic improvements alone are not going to apply. This is, taking the building down to the studs basically and redoing, just full on rehab where you cannot live there. That would qualify. I'm going to paint the building. That does not qualify. The owner or the owner's family members intend to occupy the unit provided the tenant has previously agreed to allow such a termination, or if a provision of the lease permits it. Car form RCJC may be used for this purpose. Note for all no-fault evictions, the owner must pay the tenant a 1-month relocation fee or waive rent for the final month of tenancy. So let's talk about leasing, otherwise known as tenant placement services. So these are some best practices so that you don't find yourself in a fair housing claim. The last thing we want is, a prospective tenant filing a complaint with the DRE or with HUD or anything like that, saying that they were discriminated against and that's why they didn't get the rental that they applied for. Whether you did or not, this claim can come up pretty easily. So if you're doing leasing or tenant placement services, it's good to have a standard of how you approve applicants, and that applies to every single property that you are placing for lease. And you can use this as a model if you want. I'll provide this document and the recording in our Facebook group. So set reasonable, non-discriminatory eligibility standards and stick to them. The application and selection process must be non-discriminatory. The first step to achieving this is to establish minimum criteria which all applicants must meet. The criteria may include credit standards, verifiable income, income to rent ratios, eviction history, and rental history. A conservative risk management approach is to work with the first tenant who has provided a fully completed application that meets the criteria. Consistent fair housing procedures for leasing services. So let's talk about applications. Make sure to offer an application to all prospective tenants who come to the property. You'll notice that sometimes when you go to visit a rental, there's just a stack of applications like right on the counter. That is a good way to do it. You can do it as a follow-up, like, hey, here's an application. Thanks for visiting, or however you want to do it. But to make sure that you don't get some sort of fair housing claim saying you didn't even offer them an application, do one or both of those. Make sure each application is completely filled out. Get one application from every person over 18 years of age. Differential treatment. Ask all phone applicants the same non-discriminatory questions. Use the same phone sales techniques and same enthusiastic tone of voice. Provide all applicants with the same info about the property, available units, rent, and security deposit. Handling discriminatory questions. Example, what kind of people live here? An answer might be, we are an equal opportunity housing provider and everyone who meets the qualifications is welcome here. It's okay to sound a little bit like a robot, especially when it comes to leasing services, because a fair housing claim is very easy to come by. And even if it's unsubstantiated, it can still happen very, very easily because tenants get upset, especially if they have been rejected multiple times. They might start to feel like they're being discriminated against for one reason or another, or maybe, you know, they're just trying to do whatever they can to get the place. So it's okay to be a robot, you know, and be very strict with, these are our guidelines. If you don't meet them, then you're not going to get the place. And same thing with, you know, your responses to questions like that. Just, you know, be robotic with it. A little bit of Section 8. So mandatory Section 8 rules. A tenant cannot be refused on the basis that they're applying with a Section 8 voucher. So do's and don'ts for Section 8. Don't advertise that Section 8 tenants are not accepted, nor any restriction on that basis. Starting January 1st of this year, offer the Section 8 tenant the option of having their application reviewed on the basis of their ability to pay rather than their credit history. If the tenant does not elect ability to pay review, then check the credit of a tenant, including Section 8 tenants. They can apply a rent to income ratio, but the ratio can only be applied to that portion of the rent for which the tenant is responsible, not the full amount. Dues, the landlord can set their own rent, even if the rent is higher than the amount that the local housing authority will pay. But the higher rent amount may not be a basis for automatic denial of a Section 8 tenant. The landlord must still engage with the HA to see what they will offer. The landlord cannot deny a tenant outright on the basis of perceived delays. The landlord may charge their normal security deposit. So if you run into, you know, a situation where the prospective tenant has Section 8, here's your do's and don'ts. Service animals, that question comes up quite a bit actually. So service animals and emotional support animals, ESAs. Landlord must accommodate the tenant by making an exception in their no pets policy. For service animals where the disability and the need is obvious, no documentation can be asked. For animals where the need or disability is not obvious, such as for ESAs, the emotional support animals, the LL may request documentation that the tenant is disabled and that the animal is needed to reasonably accommodate the tenant's disability. It is not required that the tenant disclose their specific disability, and the LL cannot inquire about it, so you can't ask them what it is. The verification may be provided by a medical practitioner or any reliable third party in a position to know of the disability or disability-related needs. Online certificates given without any individualized assessment of the disabled person's condition do not qualify. But if faced with this, LL should engage in an interactive process and request additional information. Trust fund handling. So trust fund violations are the most common violations found in DRE audits. Of the 10 most common audit violations, 7 are some type of trust fund violation. So even if you don't think that you have a violation or that it is a trust fund or money that should be deposited into a trust fund, it might be. So you have to be very careful with these. The categories of trust fund violations include setting up a trust fund account, recording, keeping, requires maintaining a separate record for each beneficiary or transaction in addition to a record of all trust funds received and paid out. Monthly reconciliation, no commingling, improper supervision. So those are some of the most common. This means the property managers need to build expertise in trust fund handling. Accepting any funds from a tenant on behalf of the landlord is considered trust funds. This includes credit application fees. So do not ever accept those. Use a third party, please. Some additional property management pitfalls, which includes leasing, duty to maintain habitability. So this one, you probably don't think about this one a lot. Maybe the property is just not in great condition, but your investor client has asked you to get it rented out. They want to spend minimal amount of money getting it ready for rent. I would suggest avoiding properties that require a lot of repairs or where the owner is unwilling to do repairs. Even the act of tenant placement services can involve you in a dispute between a tenant and landlord because you were representing that landlord. So, look at the property. You're putting your stamp on this as well. And more than likely, if you represented the owner and put together the lease and did the whole thing, that tenant, even though your job is done and you leased it and it's over, the agency is done, everything's done, you can expect a call from that tenant more than likely if the owner is being non-responsive, they're refusing to fix things, there's lots of stuff wrong with the property. So you don't want to be in that position because you're going to start getting looped in on everything because they automatically assume that you are the property manager, even though you are not the property manager. So you'll want to distance yourself from that if that does start to happen, but be a little selective or, put your client on notice that these, in order for you to get this property leased out, you have a minimum set of standards as well. So to keep both of you out of court. Got a quick question here. Well, that was kind of long. I'll get that one in a second. Disclosures. Disclosures are different from sales. Lead disclosures are especially key. Make sure you have those if, the house is pre-78. Termination notices. This one too, I see agents get caught up with this one. Avoid providing any termination of tenancy notice except with the advice of an attorney. I know you want the listing, but don't get sucked into this liability trap where, the owner comes to you and they're like, oh, I got these tenants, they're not paying, or I got these squatters, I can't get them out. Can you help me? Can you serve them a notice? I need to get them evicted. Now you're doing property management. And if you don't know the process of that, especially with local ordinances and everything else, you're creating a huge liability for yourself and for the owner. I don't even serve notices. I refer them over to an eviction company. You can do it, send them to an attorney as well. There are eviction companies out there all over the place, and that's what they do. Their specialty is evicting tenants. So they will make sure that it's done right. The fee is not that bad. It's like $600 to $800 usually. And they're gonna serve them the notices and they're gonna get them out of there. So, refer that kind of stuff out. That is not only gonna be a huge, huge headache for you, it's a huge, huge liability for you. And I know you're trying to get the listing, but it's not worth it. It truly is not worth it. Deductions from security and lease-ins. Avoid getting a dispute over disposition of the security deposit at lease end when money is held in trust account or with the owner directly. Again, we're not doing property management here, so the trust account doesn't apply. If you did tenant placement service and the owner is holding the deposit, and maybe the owner calls you up and says, hey, the tenants they gave me the 60-day notice, they're going to be moving out. And they do, you go there, you do the move in, move out with them. And then they start arguing or they start asking about deductions from the security deposit that the owner is assessing them. Maybe they're not getting their full deposit back or whatever. Defer them straight back to the owner because, again, you're not doing property management. You did tenant placement services. So say you're going to have to handle that with the owner. I do not, I'm not managing this property. So the owner is managing this property individually. So just don't get caught up in those conversations at all and keep the communication going between the owner and the tenant if that does come up. And I think this will be the last one. So local rent control notices. Agents are not attorneys. I think we all know that. And are not expected to research local rent control laws or other local notices, nor draft such notices. But they should have sufficient familiarity with local notices to advise their clients on the need to have a local disclosure or notice. Are you keeping up with this regularly? If not, don't provide advice. Don't provide advice outside your area of expertise. Consider this just the same as, you're not a home inspector, you're not a contractor, you're not a roofer, unless you are, and you're not going to be providing advice on, how much is that roof going to cost? How much life is left in the roof? Is that water leak bad? What's it going to cost? We're not licensed for that, again, unless you are. So for property management, you're outside of your expertise if you're providing advice that you actually have not researched and are not keeping up on. So again, you take a step back and ask yourself, is it worth this right now? Like, why am I trying to answer all of these questions when I myself don't even really keep up? So you can point them and give them resources if you want, or just refer it out to a property manager. Example, City of San Diego has local just cause eviction laws. The exemption notice, similar to the statewide exemption, but in fact is a different notice. The deadline to provide the notice for existing tenants is 9/21/24. Beginning in 2024, it must be provided in the lease. If not exempt, special notice must be provided and the tenant protection guide given directly. Notice of right to operate daycare. So, if you're not keeping up on every little thing, this is a liability for yourself and for your client, the homeowner. So, leasing is actually pretty serious, and we should take it that way. I know a lot of times we just think, hey, we're just marketing it and put together a lease agreement, but there's a lot of pitfalls with leasing and especially property management, but with leasing, that we probably just don't think about on a daily basis. But because if it's not something you're doing often, then you're probably just thinking of this as, oh, I'm only making a few dollars, or I'm doing this for free, and not taking it that seriously. But actually, you don't want to get, any you don't want to get any claims against you from the DRE or from HUD when you're not getting paid. You're doing this as a favor because you didn't advise correctly, or you didn't go through, the leasing process properly, and now someone is feeling discriminated against. I'm gonna check the chat real quick. So if an investor asks us to help them buy and rent them out after close of escrow, we must tell them at that time we do not offer property management services. Correct. We will be referring them to 3 property management companies for them to select from prior to close of escrow. We cannot advise them as to which company to choose. Right in the contract, agent advises that prior to close of escrow, buyer investor should select a professional property management company or attorney. Yeah, that's all good advice, Manny. So again, in my opinion, it's not really that worth it, especially if you're doing it for no cost. If you are doing it because you're working with investors who are leasing a lot of properties, then I would highly suggest getting your standards together of how you are going to be screening these tenants, and have it written down so that if you ever got questioned, you can say, I apply these standards to every single person that applies, and every single person that visits the property gets an application. So that way it's going to be very hard for someone to prove discrimination if you have these, a standard protocol in place. So hopefully that helps a little bit. If you have questions on anything, let me know. Recording is going to be on YouTube as usual, and also in our office and in the back office. The recording's back there as well. And then I'll post this document here if you want to use any of this. I'll post it in the recording in Facebook as well. So other than that, I hope you have a great week, and we'll see you.